Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss the actions of some congressional accessories to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. On May 22nd, 2025, the U.S. House of Representatives passed H.R. 1, House Resolution 1, titled One Big Beautiful Bill Act, after President Trump, which was sponsored by Congressman Jody Arrington of Texas's 19th Congressional District. The appropriations intended to prop up President Trump's agenda passed the House by a razor-thin red margin, with zero support from House Democrats and House Independents, 2 Republicans opposing the bill with nay votes, 1 Republican simply being marked as present, and 2 Republicans not voting at all on the bill. A couple acts of courage there. Regardless of your politics, what the public may not be aware of is a Trojan horse that appears to have been tucked into the funding bill by some accessories to the apparent coup attempt. Down at the bottom of page 562 and into the top of page 563 of the 1,118-page bill, you will find section 70302, titled Restriction of Funds. The clause states, "No court of the United States may use appropriated funds to enforce a contempt citation for failure to comply with an injunction or temporary restraining order if no security was given where the injunction or order was issued pursuant to Federal Rule of Civil Procedure 65 subsection C, whether issued prior to, on, or subsequent to the date of enactment of this section." To cut through the legalese, the clause attempts to shield the Trump administration from enforcement of court orders, finding contempt for failure of the administration to comply with several court orders, including enforcement of a contempt order against the administration in at least 3 lawsuits, such as the Kilmar-Borrego-Garcia matter, where Judge Paula Zinnes of the U.S. District Court of Maryland ordered the administration to facilitate the return of Mr. Garcia due to his unlawful removal from the United States in violation of his Fifth Amendment due process rights under the U.S. Constitution, and in violation of a 2019 court order that prevented Mr. Garcia's removal from the United States, and a federal statute under immigration law notwithstanding his illegal entry into the United States due to findings of credibility in his asylum claim under U.S. immigration laws. The U.S. District Court ordered the administration to facilitate Mr. Garcia's return to the United States to restore his status quo, that being in ICE custody, where his case would essentially be restarted, where he would be afforded his full due process rights, including his day in court, before a final determination under appropriate laws and procedures is made on whether he shall be removed from the U.S. The order to facilitate Mr. Garcia's return to the United States, which is about the U.S. Constitution, not so much Mr. Garcia, was entered on Friday, April 4th, 2025. On Thursday, April 10th, 2025, after the U.S. 4th District Court of Appeals upheld the U.S. District Court of Maryland's order for the administration to facilitate the return of Mr. Garcia to the U.S., the U.S. Supreme Court, in a 9-0 ruling, upheld the U.S. District Court of Maryland's order to facilitate Mr. Garcia's return to the United States. As of today, Monday, May 26, 2025, Memorial Day, the administration has still failed to comply with the explicit order that is rooted in precedent in wrongful removals where adequate Fifth Amendment due process is denied to an individual removed from the United States. Basically, it's standard procedure when somebody is removed from the United States to come back to the United States under court order so they can be afforded proper procedure. In regards to the apparent executive coup Trojan horse tucked into the congressional funding bill by some apparent congressional coup accessories, Section 70302 of the bill would clearly be unconstitutional, as it attempts to essentially act as Congress attempting to unlawfully usurp the authority of the judicial branch under Article III of the U.S. Constitution. First, the Rule of Civil Procedure cited in Section 70302 of the Big Beautiful Spending Bill is a rule promulgated by the federal judiciary. While Congress has the power under Article I, Section 8 of the U.S. Constitution to create the lower courts below the U.S. Supreme Court, they do not have the authority to pass legislation that impacts cases that were pending before the courts prior to the enactment of such legislation. Additionally, the federal rules of civil procedure are promulgated by the U.S. Supreme Court pursuant to authorities delegated by Congress through 28 United States Code, Section 2071. Greater clarity in legislation would likely be required by the courts to potentially require them to modify the federal rules of civil procedure. Regardless, Congress cannot constitutionally neuter independent judicial authority, especially in regards to cases and actions in cases that occurred prior to the lawful enactment of litigation. Like executive orders, legislation enacted by Congress must not violate the U.S. Constitution. If legislation violates the U.S. Constitution, it can be nullified by the federal judiciary, as we have seen with several executive orders and actions taken by President Trump. As Chief Justice Roberts of the U.S. Supreme Court recently stated, the judiciary is a co-equal branch of government separate from the others, with the authority to interpret the Constitution as law and strike down acts of Congress and the President. Its job is to obviously decide cases, but in the course of that, check the excesses of Congress or the executive, and that does require a degree of independence. Happy Memorial Day as we honor those who gave the ultimate sacrifice, and keep following Executive Coup for further updates on these matters and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.